It's a very small change, but worth doing since it's a statutory change.
Gentlemen.
Good afternoon, Chairman and committee members. My name is Will Cook with the Governor's Office of Business and Economic Development, also known as GoBiz.
Andrew Sternfels, Legislative Director for GoBiz.
Thank you for joining us.
Thank you for having us.
Maybe someone can just hit the highlights of this.
Sure. So the May revision includes trailer bill language relating to the California Travel and Tourism Commission that would allow the gubernatorial appointed commissioners to elect the chairperson of the commission. The director of GoBiz would continue to serve on the commission, and GoBiz would continue to provide oversight of the committee's annual budget, marketing plan, and other administrative functions. Thank you, and I'd be happy to answer any questions that you have.
Finance, any concerns? Leo? Colleagues, any questions? Well, the staff recommendation is to approve.
With the change that was made in the recent version of the trailer bill.
With the change.
Correct.
Is there a motion? Any public comment? Call roll.
Roth?
Aye.
Glazer? Wen? Pan?
Aye. Thank you. Let's go ahead and take clarification of California Competes Authority. Is that you all?
Yes. Thank you. Okay, the May revision also includes trailer bill language relating to the California Competes Tax Credit Program that would clarify and make explicit GoBiz's authority to negotiate tax credit agreements with businesses committing to create jobs in California. So under California law, the legislature has entrusted GoBiz with $200 million in tax credits per year, and we take very seriously our duty to ensure that we're a good steward of these scarce taxpayer dollars. The proposed trailer bill language would ensure that GoBiz can continue, as we have for the past 2 years, to do a rigorous and thorough review of applications from businesses applying for the credit. Thank you, and I'd be happy to answer any questions you have.
Colleagues, questions? Senator Wynn.
Thank you. In the, I don't disagree. I think we have to do this. The one part that I'm uncomfortable with is the section D that you added in that has the reasonableness of the fee arrangement between the taxpayer and any third party providing any service related to the credit allowed. My understanding is that this is a lawsuit that's pending because we lost in the Superior Court and GoBiz is appealing it. So isn't this a little bit too premature to add that part in? I'm fine with everything else.
Thank you. I appreciate the comment. If I may give you a little bit of a background about this program. So a few years ago, the legislature and the governor repealed the old enterprise zone program because it was rife with abuses. It was originally a well-intentioned program, but over the years, it got away from its original intention. So this particular program, the California Competes program, was one component of the new programs that replaced the old enterprise zone program.
I'm sorry.
Yes.
It's a very simple question. Is it too premature for us to have this part of your overall package here when it's still pending? I don't need to go through the history.
Sure.
I know the GoBiz, your opinion on it and everything else.
Sure.
I get it.
Thank you.
And I know the opponent, I know the lawsuit, I got that.
So in our view, it is, in the administration's view, it is not premature. We feel that this clarifying language is consistent with the ruling, which basically said that the legislature had an opportunity to make specific that GoBiz can look at this specific factor, that being the reasonableness of the consulting fee, and that's what this particular language does. It allows us to, it doesn't ban any type of fee arrangement. It allows us just to look at these consulting fees that we have been doing for the last couple of years. And what we've seen is the vast majority of consulting fees are reasonable. There's no problems with them. I'd say 95 to 96% of the consulting arrangements we see, we don't even bat an eye at. But there are those, 3 or 4% where they're multi-million-dollar tax consulting fees for an application that takes 1 or 2 hours to complete. How does that, please?
How many cases are those?
I would
do you
say
discover?
we have discovered, so we operate the program through 3 separate application periods per fiscal year. We receive roughly 250 to 300 applications per cycle, per application period, and usually we see about a half a dozen or so of these really exorbitant, egregious consulting fees. And if I may, just give some brief background on this tax credit, because it is unlike any other tax credit on the books today, in that it allows businesses to tell GoBiz how much tax credit they need in order to make commitments in the form of job creation and capital investments in California. The whole intent of this legislation was to spur job creation in California. And if a business is on the hook for a $2 or $3 million consulting fee, which we have seen before for an application that takes 1 or 2 hours to complete, they're going to inflate their tax credit request. And what that happens is that means there's less credit available for other businesses to create jobs in your districts. So what we do with these rules that have been in place for the last couple of years, if we identify one of these exorbitant consulting fees, we will bring that to the consulting fee company's attention, identify and ask them to explain the reasonableness of that. And typically what happens is they'll come back with an amended agreement for a significantly less consulting fee. Now, we're not talking thousands, we're still in tens of thousands of dollars, so they're still making quite a bit of money for a application that takes a couple hours of work. And we will then reduce the amount of credit awarded to the business, thereby freeing up tax credit available to award to other businesses.
I think Senator Nguyen's question having to do with a lawsuit, I mean, I assume you can, this is not being done to impact the result of the lawsuit.
No, this is,
So I guess you would be able to state that whatever decision we make here with respect to this particular rule will not apply to the pending lawsuit.
it would clarify our ability to look at the consulting arrangements. So the litigation surrounded a regulation that we have that is specific to contingency fees, and that's what the focus of the litigation was. However, the trial court's ruling did go a little step further and say GoBiz shouldn't be looking at these consulting fees.
I think Senator Nguyen is concerned that we vote this out, somebody runs down to the Superior Court or the Court of Appeal and files a decision and says, here, look, the legislature just said, Judge, you're wrong.
Well, the trial court ruled that if the legislature wanted GoBiz to look at consulting fees, they would have been specific and given us black letter authority. This proposal does clarify and make explicit our authority. We think the legislative intent language in the bill that created this program gives us that authority. The legislative intent, your intent language you put in the bill says that the California Competes Tax Credit Program is supposed to be transparent, accountable, and that we maximize the effectiveness of these limited taxpayer dollars.
So, because I want you on record. So you're saying then is what we are doing today, and, besides the fact that I think this is a policy issue, not a budget issue, this should have gone to Government Finance, which I'm on Government Finance and the Vice Chair. But besides that view that I think it should go policy before it comes here to budget. I'm just repeating what you're saying, is that voting this in would not impact the appeal and hurt us or allow the third party to go to the Superior Court and, and start another process or to go to this, the appeal court. I'm not an attorney, so I don't know all the process, but I mean, you're confident that this is not going to impact that lawsuit.
Okay, so as I said, I'm not an attorney either. Okay,
yeah,
so
it's a simple yes or no.
The lawsuit, well, I'm not an attorney, so I can't give you, legal advice in that regard. But the lawsuit focused on our contingency fee regulations. This language codifies what we feel the legislative intent was originally for allow us to do this holistic review of applications for businesses for the tax credit. So this language will clarify that and make explicit that it was always the original intent for GoBiz to be able to negotiate these tax credit agreements and look at a variety of factors, including the reasonableness of the fee arrangements.
I think you should assume that since this is not a change but a clarification, that the parties can use it however they need to use it in the litigation.
Okay, thank you.
Well, I'd have a question on the contingent fee business. To some extent, contingent fees are, as I recalled, designed to account for the risk of non-payment. Sometimes you win, sometimes you lose. In this case, sometimes you get a tax credit through California Competes, sometimes you don't.
Right.
And a consultant, a lawyer, an accountant, a financial manager, whatever, a tax professional may take on the work and spend a fair amount of time doing it and not, with a contingency, not receive anything because no credit is awarded, the client doesn't have to pay. And so if I understand the regulation, the contingent fees may not exceed the product of the hours worked and a reasonable hourly rate. So that really doesn't allow for any account for the risk of loss.
Well, the way, so that that
My
contingency.
question makes sense?
Yeah, absolutely. And so what how we administer that is a reasonable hourly rate can include the fact that if there is not a award, there's no payment. So the reasonable hourly rate is based on the notion that, hey, if I don't get the award, I'm not getting paid. So that hourly rate is going to have to be a little bit more than what your standard hourly rate is. But the issue is here, and let me give you, relay some testament that we received from a small business owner. So when we created our application, which is an online application, I said it's really easy to use. Doesn't take a lawyer to prepare, doesn't even take a CPA to prepare. We had a small business owner that never files their own tax returns complete our online application, and she sent us a note praising us for how easy and user-friendly and intuitive it is that she was able to complete the application, 90% of it, in 20 minutes, and she completed it on her iPhone while sitting on her couch watching TV. So it's not something you need an advanced degree to complete. It can be completed in a matter of hours. It's the same application whether you're creating 10 jobs or 1,000 jobs. So you're not seeing people spending thousands or hundreds of hours completing these applications. So to your point being, yes, we're not banning contingency fees. We just ask for them to be reasonable, and that reasonable hourly rate can be based on the notion that you don't get the credit, you need to account for a little bit higher hourly rate than what you would normally charge. But what we do have a problem with is with these multi-million-dollar consulting fees for an application that takes 1 or 2 hours to complete.
Well, I just ask you to take a look at that because in the law business, if these issues do come up in court.
Sure.
And courts look at market rates, and so they'll do an hourly rate survey of law firms and determine what the reasonable hourly rate is, and that reasonable hourly rate is not inflated because of the risk of non-payment or risk of loss. You apply a multiplier. So there's a different way to do this, and I think you all are doing it, that I just ask you to take a look at that.
We'd be happy to revisit it and take a look at our regulations. And again, this change in statute or clarification statute does not touch contingency fees. It just says that, hey, go biz, you can ask for these consulting arrangements and make sure that they're not $2, $3, $4 million windfalls.
Last questions, Senator Glazer.
But listening to you, you seem to have a problem with, or you seem to be promoting an hourly fee as what you think is a fairer basis. Would that be unfair?
Well, we just want, ultimately what this language does is allow us to evaluate the reasonableness of the fee. Through our regulations, which are subject to the litigation, the contingency piece, that's where right now we do have in the regulations a cap, if you will, of the product of numbers of hours of service provided by the consultant and multiplied by a reasonable hourly rate.
It sounds like you have a bias against contingency fees.
No, we have a bias against windfall contingency fees. The $2 or $3 million consulting fees for a few hours worth of work, because it impairs our ability to create jobs. Because if a business is on the hook for...
I get that. And listen, we're all on the same page here. But I find that one of the challenges being in this new job for me is policy by anecdote. And we always hear anecdotes on all sides. And it's always a challenge to kind of piece through those. You have irresponsible behavior all the time, but yet we're not going to manage every moment of your life to make sure you're a straight and narrow citizen of our country, right? So there's a balance in trying to figure out where we should reasonably establish some standards in place of what the private sector might decide is reasonable for them. And I hear this again and again from you, the multi-million-dollar abuser with no information that you're providing to us on that. I mean, of how many applications have you gotten? How many times have you seen that? How many times have you awarded it? You're giving us no context except for that wonderful anecdote.
Well, yeah, then the context is that when the senator asked, how often do we see that? And, I indicate about a half a dozen times each application period where we have, roughly 250 to 300 applications for the credit. We do see those exorbitant fee arrangements. And so under our existing rules that we've had in place for the last 2 years, we've never denied a business the credit based solely on the consulting arrangement. What we do is we push back and say, this is a problem. This is...
What are you proposing that's different than what you currently are able to do right now?
Well, if the... so what this is proposing to do is to allow us to continue in the event of an adverse court decision that went beyond the original complaint that was focused on contingency fee regulations. This just narrowly says, GOBIS can continue to evaluate the overall reasonableness of those fees, and that way would allow us to do that evaluation of each and every application's consultant fee arrangement, something we've been doing for the last 2 years.
What kind of disclosure are you providing to applicants about that review that you conduct on fees?
Yeah, so we do enormous outreach. I challenge you guys to find a program that has done more outreach in the short period of time that we've been in existence. So since inception of the program, which
I'm not talking about general outreach. I'm talking about the standard that you're going to be using to determine the reasonableness of the proposed fee.
Well, we ask we just tell the applicants, it's okay, so we're evaluating the fee arrangement. It would appear that this multi-million-dollar arrangement is an outlier, and then we ask them.
That's in the context of where you think something's been abused or it's not reasonable. I'm saying, what are you doing to prepare an applicant for an understanding of how you're going to evaluate the reasonableness of the fee that they may or may not be paying?
Well,
do you give them some written notice, and if so, do you have that? Can you share that?
We have a wealth of information on our website, and we do talk about it extensively in our workshops, and we have a customer service staff available to walk businesses through the application. And so it's verbal, it's on our website, our regulations on our website, and it's a case-by-case evaluation. So we can't say this fee is automatically unreasonable, because we do ask, okay, what's the amount of services you're providing? What are you doing? How many hours have you spent on it?
Unless you're providing clear standards, it makes anyone be worried about how they're going to evaluate it. I mean, is what you are doing reasonable in and of itself? I mean, and we've talked about this, but this trailer bill, law by trailer bill I've never been a big fan of it. I know in certain circumstances it needs to happen, but I do share the concerns that have been raised about why this shouldn't be reviewed in the appropriate committee. You're saying it's all contingent on losing a court case.
This would preserve, if we get the adverse appellate court ruling, this language would preserve our ability to look at the...
Right, yeah.
Senator,
And it could be challenged again.
if I could go a step further, I think our position is that the legislature it gave us explicit authority to negotiate with businesses applying for the credit. And we believe that you gave us that authority so that we could ensure that every job was the best bang for its buck as possible. And so what we're asking for you is to clarify in several areas, including the area around the reasonableness of the fee, that we should be able to look at that information and negotiate with the business who's asking for a credit to make sure that they're not asking for an exorbitant credit for, in fact, what they're doing. And so I think, to summarize what our position is, that we believe that you asked us to be as astute in our review of these applications as we've described in our regulations, and we just want to make sure that that clarification is also in law.
And I appreciate that, and I think we share your goal. I certainly share it. I imagine my colleagues do the same. And you are accountable for those choices that you're making. You're spending a lot of money, and we expect you to have, good standards and guidelines of the choices that you make, so you can do your jobs well, and you have the trust and confidence of the legislative body that you're doing that well. And but I'm struggling still because it's not clear to me that you're providing, if you're going to evaluate that fee issue, and as the chairman has mentioned, contingency fee arrangements are not based on necessarily the work that you put in to complete your simple 1 or 2 hour application. There's more to it than that. And I just would like to be clearer about how those standards are laid out and understood so that you, they, us can all understand the reasonableness of the evaluation.
Senator Nguyen.
And I agree with that. I mean, there are businesses that, unfortunately, some of them are mom and pops as well, and they don't have the ability they don't have the staffing to do it, and they need these tax credits. That's what it's created for. And we share your goals. Tax credits are supposed to help build jobs, helps businesses, and et cetera. Okay. But, I mean, for me, it's, if I'm driving and I'm going 45 miles an hour, the police officer who pulls me over is going to show to me that I'm now at 50. And he will show me that I'm at 50, so I violated the rules. You don't have that standard. I mean, it would not hold in court if the officer doesn't have anything. I saw her, and she looked like she's driving a little bit too much and not. That's what you're saying, is that what's reasonable? I don't understand still. I mean, reasonable could be it's your opinion versus mine, or his versus yours, whoever's looking at and evaluating that specific application. And again, that's why I think that this part, I'll move for everything except for D. And we should take D and allow Government Finance Committee to work with you to let's develop a standard. Let's develop, here's what we believe is reasonable. If it's $10 million credit, it should be no more than $1 million. Or I don't know. I'm just making this up right now. I don't even know what it is. So, I think that way it does help the businesses as they're going in, to know what is reasonable and what's not. But again, reasonable it's in the eye of the beholder, whoever is evaluating. It could be, I mean, for me as a business, hey, if I can get you to do the job for me, put the application, and yeah, it could be 30 minutes. Because if that company, if that's their job and that's all they do, they're now expert at it. So it could be less than 2 hours. I mean, trust me, when I go to attorneys, I don't think it's reasonable in the cost they charge me, you see? So, the attorneys believe it's reasonable. They're the expert, they know it, they're knowledgeable. I am hiring them for their expertise to protect me or to get me that contract or to get me that tax credit. Because if the tax credit application is wrong, I, as the applicant, could get in trouble by you as well. So I want to make sure that I dot all my I's, cross my T's. I'm still, and if the Superior Court comes back and say, go business right, I'm with you. But right now it's still pending. So
Senator, I appreciate your comment, and I think that the intention of our proposal is not to determine individual thresholds for tax applicants and come up with a definition for reasonableness. I think our intention is to ensure in cases where you have an egregious credit ask that appears to be a waste of taxpayer dollars, that we have at least the ability to look at that and to have a conversation with the applicant about their application and the amount of credit they're asking for, to ensure that the amount they're asking for is actually what they need in the case of a multi-million-dollar credit.
Thank you. So one question is that actually just in terms of outcomes and data is that I understand we have a fixed amount, right, of tax credit. So it's not that you hit a certain standard, and that's why I know you talked about the history of we won't need to go through that, right? So we're trying to figure out how to make the biggest bang for our buck, these jobs, right? And you've been doing this for 2 years now, right? So how many jobs have we created through this program?
Sure, I'd love to talk about some of the awards that we've seen to date.
Well, just cumulatively, how many?
Well, okay, so if I may, the awards are based over a 5-year business cycle growth,
Sure.
right? So as of today, over the next 5 years, the commitments of job creation are over 50,000.
Okay.
50,000 in committed jobs over from the next 5 years.
And I assume, and obviously, since there's over 5 years and you've only been in business for 2, we don't know what the actual final tally will be, but the projected is 50,000 based on so far. So that's,
Correct. And the
that's
credit,
good news.
the credit is contingent, Senator, on the company meeting their milestones. So they do not get the credit if they do not meet their job creation milestone.
And so when you evaluate, so I hear, and I agree, I think hopefully everyone here agrees that we should try to maximize the number of jobs we create based on, given the amount of money we have for the credit, right? So when it comes to the, so I just want to clarify, because you said, obviously, if someone has a contingent fee that's part of their application, I assume that what would happen is that if they receive the credit, that some of that credit will actually not go to creating jobs, but to trying to pay back the fee, correct?
That's the issue at hand, correct.
Okay. And do you factor, so when you do your evaluation, and I think it's good that you actually go back and talk to the consultant and maybe drop a few hints there, do you actually try to quantify so does that affect your quantification on the number of jobs that applicant will create versus the amount of credit that they're asking for?
It's an indicator of the need, as Andrew mentioned earlier. If 35-40% of the total credit award is being rediverted away from job creation, the business didn't need that amount of credit. And when you have that much credit being rediverted to windfall fees, it makes less credit available to award to other.
But that would make the application much less competitive, then I assume, because you're looking at ratio of jobs created to amount of credit being used, right? When you evaluate these, I mean, how do you evaluate?
Right. There's a ratio, a cost-benefit ratio that we've determined, and certainly if that plays a role in that evaluation. But the sheer magnitude of a business creating lots of jobs and lots of capital investment, that fee, that impact of the fee may not be as much in that cost-benefit ratio.
Okay. So in my mind, I think that what the goal should be is to look at an application and maybe provide some feedback before you make the final determination if they want to make some adjustments to try to maximize the number of jobs for the credit, right?
Absolutely. I mean, this is a negotiated agreement, so there's a lot of back and forth, and this is just one element that we incorporate.
Right. And so I personally think that it's appropriate to say that you look at the fee. I can see where it makes sense that, I mean, again, when we're the budget committee, I mean, I think to clarify the intent to say that you should look at the fee, I think sounds appropriate. I think the challenge is defining reasonableness, but I would say that we should do it in the context of, again, how's the fee impacting the competitiveness or the quality of the application itself? Because if it's drawing money away from creating jobs, then and that's making it less competitive with other applications, then that's doing a disservice to the business that's applying. So maybe a standard should be applied based on, or maybe it's the larger standard for the whole application. And when you negotiate, suggest that they can make themselves more competitive. I assume when you're negotiating, you're not saying that you're going to get the grant now. We're now going to negotiate. Or are you negotiating at the point where we're saying we're evaluating which ones we'll get, but we're going to negotiate to see, and then we'll make the decision after we first see where the negotiations land.
That's correct.
Okay, so that could be part of the conversation, negotiation then, and your feeling is that we need to have trail language to allow you to have that conversation about the. Okay, all right. Well, maybe there's a different way to. And maybe that's, again, a proposal to go back to politics. But I certainly can be supportive of having some language that says that, to clarify that you can have that conversation to talk about when you look at the overall application, because I do believe that's the intent. We want to have the maximum number of jobs for given the amount of tax credits we have, that certainly that should not be out of the scope of a conversation about how good or how competitive that application will be in order to be able to actually be successful to get tax credit. Thank you.
I'm a big fan of GoBiz, and I think you all have done a great job, and administration has done a great job with this particular program. Having said that, I'm not quite sure that I understand the need to review the financial arrangement that a business has with its service provider, accountant, attorney, and the like. Because at the end of the day, I think Senator Pan touched on this too. At the end of the day, the metric is, have you created the number of jobs that you have contracted with GoBiz in the state to create? And if you haven't, I seem to recall there's a clawback, isn't there?
Right. You know, you have to perform in order to get the credit, in order to claim the credit originally. But I guess the point is that, you know, the idea, the notion, the actual clear legislative intent, the articulated legislative intent in the bill that created it is that we're tasked with maximizing the effectiveness of this finite amount of tax credits. So we're statutorily tasked with negotiating these agreements for the best interests of the state.
Those are the amount of the credit is based on what you determine the objective to be in terms of the number of jobs, boots on the ground, right?
But we're paying too much for those jobs because the business gets to tell us how much tax credit they need. If they're on the hook for a multi-million-dollar consulting fee, they're going to tell us they need more credit than they really do need, so that they. So
there's no way to. I assume that you had some sort of formula and approach to drill down and determine whether the credit, how much of a credit you're going to need to get the 350 jobs or 500 jobs.
No, it's every applicant it's a case-by-case application where the applicant gets to the business, because they have a bottom line that they know in order to be able to create X amount of jobs and when and where and how quickly, they know the amount of tax credit they need. So they know their bottom line. And if that bottom line, it has to account for if they're on the hook for a multi-million-dollar consulting fee. So they'll tell us they need more credit than they really do, which that's what impairs our ability to create jobs. If a large percentage of the tax credit is being rediverted to pay for these exorbitant fees, it's impairing our ability to provide tax credits to other businesses.
So I think what I want to do is I'm going to hold this open and refer it to the full budget committee so we can have a more robust conversation about this with more people on the dais, since we can't take it to a policy committee apparently. So we will revisit this. But I would like to ask you to take a look at that contingency fee piece. I don't think that's quite
Certainly, we'd be happy to.
on point.
Okay.
If I'm correct, that contingency fee arrangements are designed to accommodate both the wins and the losses, and you would typically receive more money, maybe even more than you think, when you win, because 6 other times you've lost and you didn't get paid. And I think that's how it all sort of works out. And you may even upfront some money for the client in terms of doing whatever work is required. So we'll take it up with full budget. Any public comment on this one? Yes, ma'am.
Hello, Mr. Chair and members. This is Sarah Flocks. I'm here from the California Labor Federation, and I'll be at the full budget committee if this issue comes up again. But just wanted to state and give a little bit of background, because we were involved in the effort to create California Competes and part of the governor's economic development initiative in 2013. And we supported because California Competes is a very open process. It's one of the most open processes for awarding tax credits. But the other reason we supported is because of the problems that we had encountered in the enterprise zone program. This was a reform of the Easy Tax Credit program. One of the major issues we saw is that the structure, the way that the enterprise zone program was designed, is that it created incentive for consulting companies to come in, to send letters to businesses that were located in enterprise zones and say, we will get you free money, we will get you tax credits. And they would go in and they would retroactively figure out how to get a tax credit from the business, and then they would make all of their money off of contingency fees. So the intent of creating California Competes was to maximize the use of taxpayer dollars and make sure it was going towards creating jobs. One of our big concerns is that these companies would figure out once again how to siphon taxpayer dollars away from jobs and into contingency fees. So part of this clarification and the reason we support is to make sure that there's something that GoBiz has the ability to judge reasonableness, and whatever that is, if it is a public standard, I think that's fine, and to make sure that this doesn't happen again. We participate in all of the California Competes board meetings. We have great faith in that board to make decisions of reasonableness. Mike Rossi's on that board. We have Department of Finance on that board. So we do think that this decision is in very good hands with both California Competes and that board. So we would support this clarification going forward. We think it's important to have safeguards. It might be not an issue now. We don't know if it's going to become an issue in the future. And so that's why we're very supportive of this. Thank you.
Thank you.
Good afternoon, Mr. Chair and members. My name is Aaron Laurel. I'm here on behalf of the California Association of Local Economic Development. In my day job, I'm actually the Economic Development Director in the City of West Sacramento. But we're here on behalf of CalEd to support the trailer bill language. We think Cal Competes is a great program. It's only been in existence for 2 years, but part of what makes it great is that flexibility that the staff has alluded to. But we do also think that we need to strike a balance between that flexibility and having sufficient accountability and transparency into the process. And we think these trailer bill proposals are a step in the right direction there. So it's a precious resource. There's not a lot of tax credits available, and we don't see that really changing much in the foreseeable future. So we want to make sure the dollars are stretched to the fullest extent. And we think it's good public policy for the trailer bill language. So thank you.
Thank you for your comment. Any other public comment? Finance, I didn't ask for comments from you.
Yeah, I would just say that we think this is an important provision because it helps to give the Cal Competes Tax Credit Committee the flexibility to make sure that the credits are used as efficiently as possible for stimulating the economy, creating jobs.
Leo, any comment?
Brian Weatherford with the Legislative Analyst Office. We'd only note that we haven't raised any concerns with the trailer bill language.
Full budget it is.
Thank you.
Thanks, sir.
Thanks.
Item 7730, Franchise Tax Board, Issue 1, Advanced Strategic Aircraft Tax Credit. Is that
I'll be
you?
presenting, yeah.
My understanding, we're simply adjusting the start date because of a delay in the contract.
Exactly, yeah.
It's been moved. Please call the roll.
Roth?
Aye.
Glazer? Nguyen? Pan?
Aye.
Item 0860, Board of Equalization, Issue 1, Centralized Revenue Opportunity System.